Good evening and welcome. I'm Matt Jacobs, Director of the Bob Graham Center for Public Service. Thanks so much for joining us, both in person and remotely tonight. We've got a great event tonight on the death penalty in Florida and changes to the legislation around that, and I'm really looking forward to the conversation we're going to have. I want to begin first by thanking the whole team, as usual, for putting this together, the UF events folks and Marianne Vernetson, our Associate Director and Public Programs Coordinator. But I especially want to thank Teresa Cornichione, who's advisor for our mock trial UF litigators team, which is one of the co-sponsors with us tonight. She's also, part of her position is to coordinate pre-law initiatives in the College of Liberal Arts and Sciences. And so she's done a lot of the behind the scenes work putting this panel together and putting this event on. So I'm not sure where Teresa is at this point. I saw her bouncing around here a couple minutes ago. Oh, she's sitting in the back, sorry. So thank you, Teresa, for your work on this. I also want to thank the litigators. So just a quick background, the litigators came into the Graham Center last year, so this is their second year here in the Graham Center. We really appreciate having them here as part of the center. And one of the reasons why we thought it was a good fit for us is that a lot of folks go into the law for a variety of different reasons, but many of them, in their own ways, even if they're in the private sector, end up serving in their communities in a lot of different ways. And so public service and leadership and engagement really is, I would argue, critical to being a lawyer, to being a legal professional. And you're going to hear today from some folks who epitomize that from a variety of different perspectives in that profession. But it really is central to being a public servant, or public service is central to being in the law as a profession as well. So I'm really grateful to the mock trial. The litigators have worked with us to put this on. I think it's going to be a great event. I'm going to get out of your way and turn it over to Esha Bhat, who, from the litigators, who's going to do some introductions and get the program moving. Again, thank you for joining us. We look forward to the program. Esha?
Hi everyone, I'm Esha Bhat and I'm the Vice President of the UF Litigators, and I'm so excited to be here tonight, so thank you all for being here. A couple of other thank yous from me before we begin. First, thank you so much to our panelists for being here tonight and taking time out of your busy schedules to talk to us about these legislative changes. Thank you to the Bob Graham Center, including Dr. C, Marianne, Dr. J, and Issa for putting this event together. Thank you to Molly, who will be coming up later here, and she'll also be leading our audience Q&A. She also helped put together our discussion for tonight. And thank you to all the litigators for being here tonight and for helping set up for this event. If you guys don't know, like Dr. J said, the litigators are UF's competitive undergraduate mock trial team. In just the past 3 weeks, the litigators have brought home 6 team trophies and 9 individual awards. So we're off to our most successful season so far. And hopefully in a couple of months, we'll be bringing home a national championship. But enough about us. Moving on to some housekeeping matters before we begin with our panelists. We are live streaming this event. So when we move on to our audience Q&A portion, if you want to ask a question and you're online, you can use the comment bubble at the bottom right of your screen. If you're sitting here with us today, we'll be having somebody pass a mic around. We'll also be holding a reception after this at 6:30, so please join us afterwards for some snacks and to chat with our panelists. All right, so with that, we'll get started. If you all just want to introduce yourself, talk a little bit about what you do, and any familiarity you have with the death penalty in your work. Mr. Buzzell, we'll start with you and go down the line.
Well, first of all, thank you for inviting me, and I've been looking forward to this, and I'm sure we'll enjoy it together. I've been an attorney since 1977. I'm a double gator, graduated from law school here after undergrad. I started handling capital cases in the public defender's office for the 4th Circuit, which is Jacksonville, and it's also the 2 surrounding counties, Clay and Nassau, probably 1983. I don't even remember, to tell you the truth. I tried 2 capital cases by 1984 with another colleague who just got finished getting a life sentence for a client yesterday in a capital trial. But so I have spent most of my career as a criminal defense lawyer, most of that in the public defender's office in the 4th Circuit, I was most recently the chief assistant public defender there from 2017 to 2021, and then I retired, but I kept one case that actually fits the paradigm we're talking about tonight. It was a resentencing of a fellow who had been convicted in 2001. I was one of the two trial attorneys back then. We handled his case when it came back on appeal because the jury voted 9-3 to recommend death on that case, but it wasn't unanimous. And after the Hearst decision in 2015, he came back and we tried his sentencing hearing again last September, and the jury came back with a 12-0 verdict for life. So after over 20 years, he was taken off death row and is serving a life sentence now. So that's kind of like the bookends of my career handling capital cases. Didn't do it all the time, but I've always been involved with it.
I'm Professor Jennifer Zedalis, and I see a few familiar faces. I'm on the faculty at the Levin College of Law here at U of F. I have been on the faculty for 22 years, and I would like for you all to know that this event here tonight that I'm sharing with my wonderful colleagues and with you is the very last thing I have on my official schedule. I am retiring November the 30th. Save the date. Remember me at high noon. If you're 21 or older, enjoy an adult beverage. I started my legal life as an assistant public defender. I tried my first case in May of 1983. I practiced in the PD's offices in the 5th and 8th Judicial Circuits. I went into private practice then, still as a criminal defense attorney, and that was back before Regional Conflict Counsel offices. So lots of private lawyers like myself and some of my close friends continued to represent indigent clients, in addition to, of course, my private clients. And you'll hear a little bit of this probably when you ask questions and my colleagues talk with you. I had lots of first-degree murder cases during the time that I was in practice. I'm still an active member of the bar, but I've got my hands full. I had lots of first-degree murder cases, but I was in relatively small circuits, for example, compared to my good friend Lou. And also in some circuits there are higher number of cases, higher number of homicides, higher number of cases where the state looks at the case and feels it's appropriate to seek the death penalty. So many of the death penalty cases I had are cases where the state filed a notice of intent to seek the death penalty up front. We were able to actually persuade the state to come off of that pretrial. My first penalty phase was to a judge, not a jury. My client waived a jury. That was no pressure. And the judge I tried my first penalty phase in front of was Judge Stephen Mickle, and one of the buildings I work in is in his honor. So it's a nice thing. I did the penalty phase depositions in the student homicide case, the Danny Rowling case. So I've been involved in some cases that were really compelling, I think, for people. I teach Florida criminal procedure. I'm the director of trial practice at the law school. I love the undergrad litigators. I have judged, there's no institutional memory. I've practice judged and judged tournaments for the litigators, and also PAD mock trial here on the undergrad campus many times. And I love you guys, and I'm proud of you, and also of my students. So evidence, criminal procedure, trial practice, that's my thing. Only until November the 30th at 5 p.m.
We'll keep that date in mind. Thank you.
Well, good evening. I'm Brian Kramer. I'm the state attorney for the 8th Judicial Circuit. I am also a adjunct professor at the Levin College of Law under Professor Zedalis, who is, I teach trial practice at the Levin College of Law. But I am primarily the state attorney for the 8th Judicial Circuit. I started my career in 1993 with the Public Defender's Office in Manatee County, I am a true ACR, if you know what that means. If you don't know what it means, then you know why. So I have spent the last about 25 years prosecuting, and the rest of my time either in civil litigation or criminal defense litigation. I have litigated multiple death penalty cases. I currently am litigating multiple death penalty cases, and in my role as the state attorney for the 8th Judicial Circuit, I handle the penalty phase of death penalty cases. I will usually assign the guilt phase of death penalty cases to one of my trial lawyers, and we work together in that regard. And I'm also the person who makes the decision whether or not we're going to seek death in any particular case. And just as an interesting aside, an assistant state attorney can, the people who work for me and prosecute cases, they can sign any document on my behalf with the exception of one, and that is the notice of the intent to seek death. So it gives you some idea of how important that decision is, that only the state attorney can sign that document. So it's a very, very important decision, and one that we take extremely seriously, and one that we utilize process to make sure that it's done fairly, and certainly something we can talk about later if that's of anybody's interest.
Of course. Thank you all so much. Now, I want to start by talking not just about what this law is, but based on your experience studying and practicing law, why do you think it was supported and passed? Dr. Zedalis, if you don't mind taking the lead on this one.
Well, there have been many changes, not only in the sentencing scheme for capital cases, and all kinds of issues dealing with jury selection, procedural issues, discovery. Now we have discovery in both separate phases. But I felt this might be the first question you all asked, and I want to say that the impetus, all right, the motivator, the public motivator, what people in the state of Florida, the legislature, of course, we have statutes, we have laws. A lot of you, from your questions, sample questions, we heard you've read the laws. We have motivators. The motivating factor for the law that went into effect in April of this year relating to the number of jurors required to make, in order for a defendant to actually receive a sentence of death was the 9-3 jury vote in the Nicholas Cruz case. And I'm happy to elaborate on that, but my colleagues could do that too.
Mr. Kramer?
Well, I was, part of what I do is I go up to Tallahassee and I work with the Florida Prosecuting Attorneys Association to legislate and help legislate. And I will tell you that Professor Zedalis is correct. That to put it, I guess, in a different way, is that case brought to people's attention the fact that leaving that incredibly critical decision to essentially a jury of one was something that decision people became very, very uncomfortable with that, and it had very, very strong support in the legislature to pass because of that decision.
Mr. Buzzell?
That was the main one. The legislative history of public comments that the legislators made in deliberating the bill show that, as it's through their social media posts and interviews that were conducted during the session. There was another case, too, that received a lot of attention in addition to the Parkland case. The lead case on that was a guy named Michael Jackson. That was a Duval County case. He and two other co-defendants were sentenced to death for a particularly, I guess you could call it brutal. You could use any adjective you want. The facts of the case were pretty horrible. I say that as somebody who's been representing folks in death penalty cases since the mid-'80s. And it actually occurred like within 10 miles of my home. But because of the results of that case, the three defendants came back on appeal because of the Hearst decision. They they hadn't had unanimous recommendations for death. And of the three, what happened was Michael Jackson ended up getting convicted again, well, not convicted again, but getting sentenced to death again. One of his other co-defendants went to trial under the new law, the 8-4, but the jury recommended 10-2 for life, so she got life. And the other defendant actually went to trial and was sentenced to life like in probably December or January. And his attorneys went fast on purpose because they saw what was coming that happened in April. So out of the three people, you had some really disparate results, even though they were equally culpable. And of course, that might segue into some of the other discussions we have to hear tonight.
And Aisha, one thing we may get to in a minute, we might as well say it now. There are either just one or two states other than Florida that go with a non-unanimous jury recommendation. And these are of the 26 or 27 states where we have the death penalty. We only have the death penalty in the United States. In either 26 or 27 states. There are a couple of states that have it on the books, but there's a moratorium on it. And so I'm thinking it could be Alabama and Missouri, but someone in here,
sure.
It's Alabama. Missouri may be in there, they may not. You know, things change while we're talking, something may be changing. So it is unusual, and I think Alabama's 10-2. Is it 10-2? Yeah.
Yeah, so on that note, Dr. Zedalis, if you want to start on this one, is Florida a total outlier? And if it is, do you think that it's influencing other states to now start adopting similar policies?
And Professor Zedalis is fine. I'm a lawyer. I'm a practicing lawyer. Will Florida influence other states? These issues are political. They're not just political, but certainly, you know, and the death penalty, we're here talking about, you know, there are all kinds of issues that Lewis and Brian deal with as practicing attorneys every day. You know, I'm active in the Florida bar. All these wonderful lawyers in the state of Florida. By the way, when I say wonderful lawyers, prosecutors, public defenders, and private criminal defense attorneys are the most wonderful human beings on planet Earth. So important to have good lawyers in the criminal justice system. When we deal with issues like this, with the exception of this one, the death penalty, and issues dealing with harm to children, abuse of children, really emotional things that everybody just, you know, that you just, you know, they're just so emotional. You know, we look at them a little bit with a lot of objectivity if we can. So when you look at the legislation, when I say it's political, it is political. There are lobbyists. The Florida Bar has lobbyists. I'm on the executive council of the criminal law section. We have to get the permission from the big bar to even take a position on issues. You know, we try to stay out of politics. But the bar, every section of the bar, including the criminal law section, has lobbyists. People like you, your parents, your neighbors, your parents' neighbors, your professors, people who live in your community, they talk to their legislators. They let them know how they feel about things like this, right? And so it is political, but asking how much influence Florida will have, I do not want to venture. Is Florida an outlier? It's 8-4's, you know, that could be characterized as extreme, but for some people it might not be. When I was in practice, you know, I'm an active member of the bar, but I obviously don't take cases. I'm a full-time faculty member until November the 30th. And, you know, when I was in practice and handling cases, we, you know, 7-5, I mean, you know, the unanimous jury verdict is new. It's something new that we just got rid of. It came in post-Hearst. It came in after the United States Supreme Court weighed in to the Florida Supreme Court on Hearst. Hearst went back down. And one of the things that the Florida Supreme Court said was, okay, now it's got to be unanimous to get death. The jury has to have unanimity, right? So if you guys are reading cases and you want to read a case called Poole, Poole, that comes Florida Supreme Court after Hearst, you'll see the rationale, the discussion of why they think the sentencing, the jurors weighing a sentencing factor and aggravating, at least one aggravator has to be proven beyond a reasonable doubt, at least one. They're 10. So much for narrowing, right? They're 10, okay? Mitigation is, lots of things. There's a residual clause. If you want to read and look at the analysis, what the court is thinking, right? So get away from the legislature for a minute, the politics. Look at the court. We have the judicial branch, and look at what they're saying about the current Florida Supreme Court, what they're saying about the difference between weighing proof beyond a reasonable doubt for guilt and weighing aggravators versus mitigators, and why they felt it didn't have to be unanimous. So you can get down into the weeds if you want to. It's very interesting, and if you want to really be informed about it, right? But so outlier 8.8 and 8.4. If you look at other death penalty states, yes.
So one thing I would say in regard to your question is this: if you were to back up a little bit and look at what is happening nationally at the Supreme Court, we've seen a series of cases that are coming to the Supreme Court with the intent of changing precedent, right? So if you look at what happened last year in the Florida legislature passed a new crime that is punishable by death, which if you go, it's capital, what we call capital sexual battery, or sexual battery by a person over the age of 18 upon a person under the age of 12. That's a mouthful. We just call it capital sexual battery. And long ago, it was punishable by death. That's why it's called capital sexual battery. But the Supreme Court of the United States said, and it's still current law, that is a cruel and unusual punishment. It's a violation of the Eighth Amendment. So the Florida legislature has passed a law in the hopes that somebody's going to be sentenced to death so that it can go to the Supreme Court, so the Supreme Court has the opportunity to change that law. So when you look at this, if you look at this 8.4 rule, this 8.4 law in that lens, then the answer to your question is perhaps other states will be looking at this or trying to take this up to the Supreme Court to get the Supreme Court to really say and answer the questions that Poole, as she mentioned, has told us one thing, which the Supreme Court really has never spoken directly to, which is the issue in Poole.
Mr. Buzzell, would you like to weigh in?
Yeah, I disagree with my colleagues. I think there's no question that it's an outlier. I think it's outrageous. I'll tell you why. In a series of cases starting around 2000, the U.S. Supreme Court, led by Justice Scalia, issued a series of opinions that basically said the Sixth Amendment to the Constitution guaranteeing your right to a jury trial means that a jury gets to make these decisions, not a judge. And the way that the Florida capital sentencing scheme was set up in 1976 in response to Furman declaring Furman was decided in 72, the U.S. Supreme Court said capital punishment in the United States is arbitrarily and capriciously applied. It's unconstitutional and violates cruel and unusual punishment because of that. Florida passed the law that we've been discussing now that's still the same structure right after Furman was decided to take into account the problems that the Supreme Court pointed out. In 1976, the U.S. Supreme Court upheld that statute. And so that's what we've been dealing with ever since. And basically what it was, a 7-5 vote, you're dead. But the jury's decision then was only a recommendation. The judge still had the ability to override it. That's how it started out. What happened for the next 10 years was judges typically overrid the jury recommendation of life and imposed death sentences. I only know one instance in our circuit where a judge did the opposite and overrode a death penalty recommendation and imposed life. The case law changed over the years, and the training of judges, frankly, changed over the years. And so probably about in the late 90s, it became the jury recommendation was essentially what the judge had to do. That was the real world, and that's the real world we lived with until these decisions by Justice Scalia. And I've told this to many people before. It's my humble opinion that you could read the case of Ring versus Arizona, and a first-year law school student would tell you that Florida's sentencing scheme, capital sentencing scheme, was unconstitutional. People tried to get it changed through the legislature for 10 or 15 years, and it wasn't until 2015 that the U.S. Supreme Court said that. And that's the only reason that Poole was decided, because the United States Supreme Court made them do it. And the only other state that has had less than unanimous verdicts justifying death during that time was Alabama, and that was a 10-2 vote. So this is my personal opinion only, but if you look at the constitutional law since 1963, when the case was decided, the Gideon case, that established the right to everybody to have an attorney in a felony case, whether they could afford one or not, that came from Florida, it came from Panama City. You look at the cases, and we used to laugh about this because the director of the Department of Corrections for many years in Florida, his name was Louis Wainwright, he was getting sued all the time by people in prison saying, habeas corpus, I need to get out, I've been unconstitutionally sentenced. And you know, what I always thought was peculiar about Florida was not only would they pass patently unconstitutional sentencing schemes, but they were proud enough of it to fight it all the way to the Supreme Court and lose. And that's what's going to happen for the next 10 years in these cases, I think. And I completely agree with Mr. Kramer that the whole instigation of passing a statute that flies in the face of a particular United States Supreme Court case, Kennedy versus Louisiana, is what exactly as he said. They want them to change their minds, and that's what a lot of this is about.
Professor Zedalis, do you have anything?
Lou said something that was really important. We're talking about death penalty cases here, and we're talking about the changes that happened this spring. But he's right about Florida. Ford v. Wainwright's a case that deals with the United States Supreme Court took up back in the 70s, also dealing with the standard of sanity, or they use the term sanity. It may be more competency. The terms are used in different ways in our practice to be executed. Whether it was constitutional to execute Mr. Ford at the point that he was set for execution in Jacksonville, did he understand that he was going to die? Did he understand he was going to be killed? And if so, did he understand why, right? So that was a Florida case. Florida is, the United States is an outlier. It's not just Florida being an outlier with the 8-4 and death penalty. The United States is an outlier with death penalty. If you want to look and see how many countries in the world have the death penalty, we're an outlier there too.
Right. Now, I do want to take a step back and talk about what exactly this law does. I think there's been a lot of discussion and confusion on who exactly it impacts. So looking at, for example, defendants who were accused prior to the passage of the law, or also those who have had their trial but not their penalty phase. That was after the law passed. Mr. Kramer, would you like to weigh in on that?
Well, certainly it depends. The trial and the penalty phase generally happen very quickly. So
Right.
The chances, like Mr. Buzzell said, of somebody hitting that perfect mark between when the law was signed by the governor are pretty low. So most cases are either going to fall on one side or the other of when that new law went into effect. So there are a number of cases that are in the system now for resentencing because their sentences were overturned, because the death portion of the sentence, maybe not the guilt portion of the sentence, was overturned under the prior law. So those people all have to be resentenced because that's what we call the law of the case in that case, right? So those are in the system. A lot of them have been dealt with. Some are still out there. So it would be pretty rare that you would have that particular situation happen, although it's not impossible that the law can change. I've definitely been involved in a case where somebody pled guilty, and then after pleading guilty and the sentencing phase was set off for quite some time, that the law could change in that scenario. So that can happen. But yeah, that's really, as far as that's concerned, where does this really affect is, it's very specific in how the death sentence is actually imposed and how it works technically. So what changed with Poole from Hearst to Poole? Because Hearst said everything had to be unanimous and the jury had to decide beyond a reasonable doubt that the aggravating circumstances existed, but that the aggravating circumstances were sufficient beyond a reasonable doubt to impose the death sentence. And so what really happened is that Poole separated the two analyses. So you have the qualification analysis, and then you have the selection analysis. And so the qualification is where the unanimous decision is still required, which is that in order for the jury to get to the selection the selection means what sentence are we going to choose? Because they can choose between life and death. But they have to unanimously agree on the qualification, which means that there has to be at least one aggravating factor that's proven beyond a reasonable doubt, and then they all unanimously agree exists. There can be more, but they have to agree to that. Now, under Poole, it's the decision on what penalty that does not have to be unanimous. And that's what's changed. That's what's moved to 8-4. So that's really where the difference is technically between people under the old law and people under the new law. Does that answer your question?
Yes,
Okay.
definitely. Mr. Buzzell, Dr. Zedalis, would you like to weigh in on that?
No, I agree with that analysis. I think the other important thing to emphasize. I'm sorry. That's why I usually leave it on. No, I agree with that analysis, and I think one other important thing, at least probably from the defense bar's perspective, is that there is uncertainty because of the way the law was written as to whether we're back now to this decision by the jury being essentially a verdict that determines what's going to happen. Are we just back to a recommendation? And that the judge is going to have to make the final decision. That will be the subject of a lot of litigation. I'm sure it's already started. And that particular aspect of the law, when you do death penalty work, everything has a name assigned to it that's usually associated with a Supreme Court case. That'll be a Caldwell issue. And, you talk about getting into the weeds. That's getting into the weeds for those of us who've done this for 30 or 40 years. But that's one of the problems I foresee with the application of the new law, is that the way that the legislation was drafted left a lot of ambiguity for some of these issues. And that ambiguity is going to be cleared up as we go in particular cases until it's finally decided at a higher level than any of the circuit courts.
Professor?
I agree with everything that Brian and Lou said. On retroactivity, so I think Aisha's excellent question goes to retroactivity. Who is this going to affect, right? So there's a case, gentleman named Brian Riley. He's a defendant here in Florida. If you're from the Polk County area, he's in custody pending trial, charged with killing a family. I think 4 members of the family and wounding another child in the family. And this issue that Brian and Lewis are talking about has been raised in that case. In June, Mr. Riley's attorneys well, let me back up. In June, the prosecuting attorney in Mr. Riley's case filed a motion for I guess, clarification as to whether they could proceed with the 8-4. When the case went to trial, they could proceed under the new law signed in by the governor in April. And there, so you can read about this. There may be transcripts. It would be an opportunity for you, if you're interested in this issue, to listen to the arguments between the defense attorneys in Mr. Riley's case and the prosecutors in Mr. Riley's case. I've only read summaries of their arguments. They argued in front of the trial court in June. I think they were well prepared. There are two prongs to the retroactivity test. One is whether the legislature intended that the law be applied retroactively. The law doesn't speak to that, I don't think. I don't think the law speaks to that. I might correct me if I'm wrong, guys, but I didn't see it. But sometimes my reading glasses are bad. So, you know, as Lou said, there's ambiguity, right? You have the legislature, they pass a law, the judiciary takes it up. That's why we have checks and balances. They review it under a lens of the United States Constitution, the Florida Constitution, the United States Constitution. It's, we have this thing where we say it's all the same now in Florida. So the trial judge denied the state's motion. The first prong is whether the legislature intended that the law apply retroactively, and the second would be whether it's going to be constitutional to apply it to people who are already in the pipeline. So they may be raising 14th and 8th Amendment claims. There are other claims they may be raising. I think it'll be interesting to see. In fact, I think, Louis, you told me, we were talking about this on the way in. I think there are at least 4 cases pending in the courts on their way to the Supreme Court or pending in front of the Florida Supreme Court right now. They're going to address this issue of whether it's retroactive or not. And it may, getting down in the weeds, it may depend on whether there's already been a trial phase but no penalty phase. But certainly there are very good arguments that it should apply to people in Mr. Riley's position who hasn't been to trial yet. The difference between a unanimous jury decision and 8-4, right? So it is ambiguous and it will have to be resolved, and it may likely go all the way to the United States Supreme Court.
If I could just say real quickly, I checked last week, and there were 2 capital trials going in the state that I knew about. There might have been others because I was just going through the defense attorney grapevine. But one was in Tampa, and the other one was in Jacksonville, and they both involved defendants who they were going to trial for the first time, first to see whether they were guilty of first-degree murder, and then if so, whether the death penalty should be applied to them. In both of those cases, the judges had decided that the 8-4 new legislation applied to their situation. The Jacksonville case was decided yesterday, and the jury verdict, or I guess you call them verdicts, I don't know what to call them anymore, but the vote was 10-2 in favor of life, so none of this really matters now anymore. One other thing I guess we could maybe just mention briefly, especially from a defense attorney viewpoint, is you have to raise all these issues before the original trial judge and litigate them then, object during the trial, file all your motions, or else they cannot be considered on appeal later, either in state court or federal court. That gets really complicated, but I guess the essential point I'm trying to make for y'all's consideration is these issues are immediate, they're happening now, and they're happening in communities all around you. And so this will be the subject of a great deal of litigation starting in the trial courts. And based on what we've seen for the last 40 years, application of the death penalty in Florida, they'll be ongoing at different appellate levels for many years.
Thank you all so much. I definitely feel like I have a better understanding of how this law might play out and how, like Mr. Kramer, you were saying, it might impact jurors and the judge. I do want to take a second now and pass it over to Molly Clemens to lead our audience Q&A. She's the treasurer for our mock trial team, so please give her a warm welcome.
Hi everyone, I'm Molly. I just want to give a huge thank you to Esha for moderating that and for working on all the questions with me. I really appreciate it. And again to our panelists for being here and of course our audience. So we are going to begin our audience Q&A portion, both for everyone who's sitting here and also everyone online. If you're on the Zoom, there should be a little question button right there in like the bottom right corner of your screen. If you want to pop some questions in there, we can have those read and answered as well. So I'd like to go ahead and get started. And if you're here, Jonah's back there and he will run you that mic. So hit us with your questions. Dr. J.
Yeah, so thanks for the presentation and for the discussion of a really complicated issue. I'm going to take actually director's prerogative and make one comment, then ask a question. The comment is, I should have mentioned this in the opening remarks. If you've never had the opportunity to serve on a jury, do not turn away from that opportunity, right? So I've had the chance to serve on 2, including a murder trial this summer, right here in Gainesville and Alachua County in the 8th Judicial Circuit. That is a public service unlike any other, and so a lot of people spend their time trying to get out of jury duty, but it is incredibly valuable, and you learn a lot about not just how the criminal justice system works, but also about our society, and it forces you to think a lot about how do people end up in the circumstances that they end up in. So that's just the comment to the audience to think about public service as serving on a jury as well and part of civic engagement. The question that you started to hit on in your last comments was, how do you think this change will alter the processes leading up to it, whether that's through training of lawyers, but also through pretrial processes in terms of preparation for this, right? If you're going to trial, how is it going to alter that process? Working with clients from the state's attorney side of things, how is that going to impact that process?
So it has a huge impact in my office, and it has a huge impact in the decision-making process that we undertake, because it is, as I started to talk about, we go through a process to reach the conclusion of whether or not this is the type of case that warrants what is an incredibly huge decision, not just for the defendant, because it's absolutely, but also for the victim, for the legal system, for the amount of resources that are going to be put towards this case, towards the amount of time that it's going to take to get this case to resolution. On average, you're talking about the difference between 18 months and 4 years. And by resolution, I just mean a trial date. Resolution of the rest of it is like beyond anything I can talk about. So when you start talking about the question of is it going to be unanimous, or is it going to be 8-4 or something in between, you as a person who's making this decision, you have to think about what you're going to say to the various people in the system on the likelihood of a result, right? So if I'm talking to a victim's family and I'm saying to them, we have to have a unanimous verdict. Any one person votes against the death sentence and it's not going to be a death case. Do you still want to engage in this process? That's a completely different analysis than if you say to them, it's 8-4. Right? And now after Parkland, I think people are very, very hesitant. And you're looking at Parkland there definitely are cases that are worse in some aspects, but from the number of people killed, it was absolutely off beyond the pale. And that was 9-3. And so you have to be able to talk to someone and say, that was 9-3. If it's unanimous, are we going to be able to achieve that in this case? And therefore, is it worth what we're going to have to do to get there, right? And so that's really, from our perspective, that's a huge issue. And that's really how it affects things. Now, with everything that they've been talking about, and what we're talking about is you also have to consider, and I have to tell them, it's 8-4 today. I can't promise you that when this case is resolved in however many years it might take to get there, that it'll still be 8-4. That the likelihood that one person, and maybe Lewis can talk more about this, will only have one sentencing hearing in a death penalty case. I mean, I think it's most likely most people are going to have more than one.
Yeah.
Yeah. And so what will it be when we have the next sentencing hearing if this one doesn't hold up? Will it still be 8-4? Will it be 10-2? Will it be 12-0? So those are the types of discussions you have to have with families in the worst moments of their entire life that they will ever have. And that's how it really affects me.
You have to have the same conversation with your individual client who's accused of it. And it affects plea negotiations, for one thing. A lot of times, what you're doing as a defense attorney in a capital case is trying to persuade the state to agree to accept a plea for life. So you don't have a trial. A lot of times, a successful outcome for us is not having the trial at all. If it's a unanimous verdict is required, frankly, that gives us a little bit more leverage in negotiation because it's harder to achieve. And likewise, this situation, 8-4, probably gives you less leverage. That's just the reality of it. That's the real world of it. Now, the other thing is that typically what has happened in Florida since I've been doing this is that the application of death penalty eats up a tremendous amount of resources within the criminal justice system. In fact, it warps it. I know people who are conservative politically, including judges who have since retired, who told me that they oppose the death penalty application in Florida because, not on a moral basis, but because it costs too much and it diverted resources from other things that needed attention in the criminal justice system. So I think that's another issue that will probably be before us pretty soon, because like I said, it started all over again already this summer. For a defense attorney, this is kind of like what we do, and so I don't think it's going to cause any more strain than what we've been doing forever. But, I'm trying to phrase this in a way that doesn't sound unduly cynical, but I probably can't. For some defendants, this is a godsend because they know they're going to lose. They're going to get convicted. A lot of times the trial, like the one in Jacksonville this past 10 days, the penalty phase lasted longer than the determination of guilt. It was all about what the sentence was going to be, not whether the guy was guilty or not. So if you lose and you have all these new issues to litigate, the chances of a death warrant being signed in your case, and you're like, what, be number 360 now, if you're first in line after these, it's going to take another 10 or 15 years before your case gets decided. And the only thing it's affecting is where you're serving your time in the Department of Corrections. Is it going to be at Union Correctional Institution, right down State Road 16, in between Stark and Lake Butler, or is it going to be in one of the other prisons in the state of Florida? That's the real world for criminal defendants. It'll give defense attorneys more arguments to bring against this new legislation that will take a long time to resolve. And frankly, that's not good for anybody in the system. It's not good for my clients. It's certainly not good for the victims' families who need resolution of these horrible situations. It's not good for the people that work in the system, and it's not a good expenditure of resources. So, anyway.
Professor Zadelis.
Just to follow up on the question about the change and how it'll affect people on both sides, and jurors too. I want to say real quickly, because I appreciate what Dr. Jacobs said. We should all respect jurors. I have tried lots and lots of cases, picked lots and lots of juries. I've had jurors convict my client. I've had jurors acquit my client. And we do the best as lawyers, prosecutors and defense attorneys. We do the best as lawyers, do the best we can to pick a jury we think will be receptive to our client. Listen, at least be receptive. Understand that you need to listen and pay attention, listen to the evidence, and really take it seriously and be fair. One thing that was troubling to me when this issue about the jury unanimity came up is, and it always comes up in a really horrific case. It always comes up in a case that's just indescribably awful, like what happened at that high school. But the lack of respect for those three jurors who listened to the entire trial, listened to the penalty phase evidence, and for whatever reasons they deliberated. They didn't feel it was appropriate. The death was an appropriate sentence. People can disagree about that. And I think we respect jurors when they go the other way. We need to respect jurors when they go that way, right? Changes. We're talking about the difference between a unanimous jury verdict on the penalty phase, and an 8-4. And Florida is certainly an outlier on that. In the last 20 years, and even before, in the time that Lou and I were on the defense side, and Brian's a baby, he's the baby, okay? We've gone from, when I was practicing death penalty, you didn't need a unanimous verdict. 7-5 would do it. 7-5 death would do it for the state. The judge could override. We had one judge in Alachua County overrode every life recommendation that came his way. That's changed. Okay, Hearst is relatively new to me. When we went to a unanimous jury verdict, that was new. Since the time I've been teaching at the law school, juveniles can now people can no longer be executed now for a crime that occurred when they were a juvenile. When I was a young intern in the public defender's office, my mentor, Johnny Kearns, who was my supervising attorney, went to an execution of one of his clients who'd committed an armed robbery at the age of 17 where there was a death, and he was executed. Right now, we don't seek the death penalty in cases where the person was a juvenile, okay? The defendant was a juvenile at the time the crime was committed. We used to refer to professionally as suffering from mental retardation. Now it's called intellectual disability. So we had Roper from the U.S. Supreme Court on juveniles not being executed. We had Atkins v. Virginia from the U.S. Supreme Court. You can no longer execute someone who is intellectually disabled. So then all the fallout from that is, well, what do we mean? How do we define that? What do we mean? So one of the issues that's going to come up in all this litigation that Lewis is talking to you about is, for example, because it's already been litigated post-conviction here, is fetal alcohol syndrome. Is that intellectual disability, right? When I was your age, I went to a juvenile law conference, and I saw, for the first time in my life, I saw brain scans, right? One of our presenters was showing us brain scans. So it's not just the jury verdict, the unanimity versus 8-4 that we're talking about. All of these issues, when the death penalty was reinstated in Florida when I was a little bit younger than you, the whole point was, well, it can't be arbitrary. It can't be arbitrary. It has to apply to a very narrow class of people. We tried to execute everybody in the United States of America who's convicted of murder. You would have to just, you know, the wheels would be turning everywhere. Has to be narrow, right? Well, we now have 10 separate aggravating factors in the state of Florida. So all of these things are in flux. It's not just the number of jurors required for a sentencing, and it is. I agree with Lou. It's back to a recommendation now. It's advisory now.
We have a question back here.
Hi, I just wanted to continue on that vein of talking about the consequences of this law, not like the constitutionality section, but how do you think this will affect how many people are sentenced to death, right? So you could think theoretically, oh, this means more people will be sentenced to death, but how common have you seen these sort of split juries? Do you think this will increase the speed of trials because, you know, you don't need to push as hard to get that 8-4? And what do you think are the policy consequences in general for recidivism and things like that?
Want to go ahead, brother?
Yeah, I don't know that it's going to change speed a great deal because death penalty cases move at, I would say, somewhere between glacial and geological speed. And the fact that ultimately the last thing we're going to do is going to be to have the jury make this decision between 8-4 and 12-0 is going to move the speed along any faster or any slower. Whether or not it's going to actually end up with more people being sentenced to death, I mean, I think that's the logical conclusion that you would come to. I don't know. I think prosecutors in general are you know, aware that we have to take a much longer view of what's happening here, and all the things that Mr. Buzzell's talking about are very accurate, and that so if you would be reckless to simply take the position of I'm just going to ask for more because it's 8-4, right? You have to be cautious in what you're doing and making a decision that you think is going to stand up over time, right? And if you've done this, and he's done it way longer than me, but if you've done it, you know that time is not on the side of the government here; it's on the side of the defendant. And if you're pushing for things that aren't going to stand up over time, then you're not a good steward of the public's resources, I guess is the way I would put it.
Well, I completely agree with that. See, we can agree on things here. But I don't think it has much to do with the vote totals. I think it has, the answer to your question, has a lot more to do with the changing attitudes of the public in regards to the death penalty. And this morning I went and looked on the website for it's called the Death Penalty Information Center. They call it abolition. They're an organization that is against the death penalty and is working to repeal it everywhere. But I think everybody's pretty satisfied that their stats and their information are accurate. They have to be accurate and transparent, or nobody's going to pay attention to them because, especially when they started, their position was quite unpopular. But they said that since 1999, death sentences in the United States have declined by 92%. I already know of 2 cases in Jacksonville where the new law was applied, and one was a particularly horrible case, and the juries came back and recommended life. So I think those kind of considerations are going to matter more than some of this technical stuff. I hate to call it technical stuff, but you know, how many jurors vote one way or another. I think a lot of times we're not even going to get to that point anymore. Maybe I'm being optimistic about that, but I'm hoping that's the case. I can just say, anecdotally and from my own personal experience in recent years, that attitudes about the death penalty in Jacksonville, Florida, which is a politically conservative place, have changed dramatically. And that's, you know, last trial I did on this a year ago, 75 people come in the jury pool. We questioned on both sides for 3 or 4 days, mostly focused on, can you follow the law one way or the other on capital punishment, or can you be fair to the state? You're going to be fair to my client. And we had 25 jurors say that because of personal beliefs, religious beliefs, those were the most common reasons, they absolutely would refuse to follow the law and would vote for life. A third were disqualified because of that. On the other hand, we had about 5 people who said, I would vote for death no matter what the judge told me. And I wouldn't consider the mitigation. So we call them automatic death penalty people. That ratio compared to what I used to see when I was selecting juries in the 80s was like diametrically opposite. Us old folks who've done this for a long time, we're surprised. And we're seeing more and more of that. And again, that's just my own experience. I'm sure there's other experiences elsewhere, but that's probably where we're at. I hope so.
I just want to add, it's possible that the number of exonerations, and Florida leads the country in people exonerated off of death row.
30 as of
So
2022.
that trickles out into the public consciousness too, like, wow, we got it wrong. That's why we have no death penalty in the United Kingdom. We have lots of colleagues who practice law over in Great Britain. They don't have the death penalty anymore because they hanged a man for killing his wife, and just a few months after they hanged him, the serial killer who lived next door admitted to being the killer, and there was evidence to back it up, and so that could be part of it too.
Well, thank you all for your questions. Oh, one more.
We have a question from an online audience member. How do you personally define cruel and unusual punishment, and where do you think the use of the death penalty could be cruel compared to the crime?
Okay. Yeah, I would define it, well, cruel and unusual punishment is a legal term. If you're an originalist, you go back and look at what was considered cruel and unusual at the time the Eighth Amendment was passed. It would probably be something in order of torture and what we would consider to be rather barbaric executions, Now it's, what's the magic words that the Supreme Court uses? The conscience of the community, or
Shocks the conscience of the community.
Right. They're looking more at it as a community standard. And like I've just been discussing, that shifts over time, doesn't it? And that's how I would define it. I'd define it as a lawyer because, frankly, my own personal views of what that means, I don't even know. And the thing about capital crimes is that for it to even qualify as a capital crime, the facts have got to be pretty horrendous. And, to equate the suffering of the victim and the victim's family with what you're trying to decide is just in court, taking everything into account, I really don't, I don't think that those comparisons in a legal setting don't really make sense. And that's one of the problems, that's one of the fundamental problems of dealing with this issue in the first place, and it's one of the considerations people have to take into account in whether they support capital punishment or not.
I agree with what Lewis said.
Yeah, the only thing I could really add, I think, is that it's an interesting aspect of this discussion that there is an Eighth Amendment analysis the cruel and unusual punishment is in the Eighth Amendment is an Eighth Amendment analysis of whether or not a non-unanimous verdict is a cruel and unusual punishment. And that's an interesting analysis. It's not one that I think, unless we had another 2 hours to explore, but I think the fact that courts have looked at that aspect of it is certainly telling as to whether the courts think that a non-unanimous verdict is shocking to the conscience of the community. And I think that's part of the future of what we're going to see.
Well, thank you all so much. I really appreciate your thorough answers and all the research you put into coming in today, sharing all your knowledge and wisdom with us. It was amazing to hear about all your experience and how that applies to our topic today. And thank you to everyone in the audience for participating so much. I was really enjoying hearing all your questions. I wish we had time for more, but unfortunately that's all for tonight. We are actually having a reception upstairs in the O'Neill Reading Room afterwards, so if you'd like to chat more with our panelists, Bob Graham Center, even Esha and I, you're welcome to join us up there for some food and some more chats. And thank you again to the Bob Graham Center for hosting this event, making it possible, and being such a great home for the litigators. We are so happy to be here, and we hope we can do another event like this with you in the future. So thank you everyone for coming.